Hello, welcome to Workplace Wake Up. I'm Jen Shaw. Every week, I spend about 15 minutes covering key legal developments, introducing you to interesting guests, and providing some entertainment to start your workday. I hope you enjoyed this week's episode. I hope you're all doing well, adjusting to 2025. We are here today to talk about union organizing. Okay, a couple things I want you to keep in mind right off the bat. If you are already working for an employer who is unionized, you know how to deal with unions, or you're at least learning how to deal with unions, right? And it's challenging. Now, it used to be in the olden days, right? The unions were a huge source of protection for employees because we didn't have plaintiffs' lawyers, and we didn't have OSHA, and we didn't have the California Civil Rights Department. And we didn't have a ton of lawyers who were handling workplace issues. So the union was really a great resource for employees to be able to make sure they were being paid properly, they were getting a safe workplace, they were not working too much, they were getting rest breaks and meal periods and all of those things. So I am not a traditional management side employment lawyer. And they generally think, unions are the worst thing since I don't know what. For me, Brussels sprouts, okay? I actually think unions have a place, they have a role. But if you're a non-union workplace, chances are you want to remain that way for a couple of very simple reasons. It's easier to manage when you don't have a third party involved. When you don't have the union telling you how to handle things and when you can talk to your employee and how you can talk to your employee and what policies can be enforced and what policies can't. When you just get to run your workplace, it's a lot easier from an employment perspective. I got to tell you, most employees also tell me they prefer to work in a non-union workplace. Now, they are interested in unions when they can get more benefits, when they think they're going to get more respect, when they think the work environment's going to improve with a union. Then they're interested in looking at a union. But overall, if you have a decent work environment, you would rather not pay dues to a union to interject themselves into your workplace. Okay, so just to be clear, I am not anti-union. I think unions have played an incredibly important role in the development of the workplace in this country, and they still do. What I want you to know is whether you are a union employer or not, the rules are changing. We are in a new era. First of all, we have a new president, a president who is going to be putting 3 new members on the National Labor Relations Board. Okay, that is the 5-member board that sits in Washington, D.C., and deals with all of the issues that come up under the National Labor Relations Act, the NLRA. Now, remember, the act was passed in the 1930s by Congress. It was enacted into law. It protects both union and non-union employees, which makes sense, right? If you're going to have a law to protect unionization, you have to protect people who already have a union and people who may want a union. So it's a very broad protection. And many non-union employers get confused and they think they don't have to worry about the National Labor Relations Act because they don't have a union in the workplace. So it's not something that they need to focus on. Not correct, okay? You do need to be sure that you are following all of the requirements when it comes to the National Labor Relations Act, even if you don't have a union. Now, a good example are 2 developments we've had for 2025. One is here in California, where we have a new law in place that restricts your ability to hold mandatory meetings, okay, when you are trying to defeat a union election. So you used to be able to say, okay, we're going to all meet at 2:00 while I tell you all the reasons why it wouldn't be a good idea to have a union here. You can't require that anymore. So we have a webinar coming up on this issue of union meetings. You can go to our website and you can figure that out in terms of registering, because it's very important that you get the ins and outs of the rule and the law, and we don't have time to go through it here today. But just know that there is a new California law that limits dramatically what you can do in terms of holding these mandatory meetings. Now, the other thing that I want you to know is on a federal level, we have also had some developments, and this makes sense because now that we have a Republican president, now that President Trump is back in office, we are going to, as I mentioned earlier, have the majority of members on the board be Republican. But until the election and until President Trump took office, it was a Democratic president, and we have had 3 members who are democratically appointed on the board. It's going to take a while for them to actually move on and the new folks to come together. But the bottom line is we need to be sure that you are paying attention to those developments because it makes a huge difference. The board has said recently, before the election, yeah, we don't like these whole mandatory meetings. We don't like how employers want to have what we call captive audience meetings. And that's exactly what Senate Bill 399 here in California prohibited, except under very limited circumstances. So on January 23rd, we are having a webinar to talk about the new rules for captive audience meetings to make sure that you all understand them, because it's not only a state law issue, it's a federal issue. So those of you who listen to the podcast outside of California, don't assume that this issue doesn't apply to you because you're not in California. This is a federal issue. It is a federal law, and it's a federal issue that we're all having to deal with. So very important. If you have any questions about captive audience meetings or just union organizing generally, you should definitely join us for that webinar. Now, the other thing to understand about union organizing is that unions win elections not because of money. There is an assumption that many folks make that the reason employees vote for a union is because they want a raise. And the truth is, if you look at the statistics and the interviews that are done of folks who are involved in union activities and want a union, it's usually about respect. It's about how they are treated in the work environment. So this whole issue comes down to what we talk about all the time, which is treating your employees like they are your favorite people on the planet, right? Doesn't mean you don't hold them accountable. Doesn't mean you don't have high standards. Doesn't mean you don't require them to meet their responsibilities. But the way you do it makes a difference. And we have to think about how you go about that and what steps you take to ensure that your leaders know how to treat people. They know how to hold people accountable in the correct way. They are not making decisions that are just off the cuff, but are well thought out, that are related to legitimate business needs and consequences. So in an HR role or an employment lawyer role, you've got to always focus on that. How are we getting our leaders to make sure they're doing things appropriately? Because that is the number one reason why people will seek out a union. They don't feel like they're being treated fairly. They don't feel like they're getting a fair shot. They don't feel like leadership is in touch with them. So if you keep that in mind, you realize that one of the most important union avoidance tools you have is how you treat your employees and how you teach your leaders to treat their teams. So a big part of your to-do list for 2025 should be making sure that everybody in your organization understands the culture, what is expected in terms of how they interact with one another. Obviously, this is challenging if you're in a hybrid work environment, right? Or people are working 100% remote. It can make it more difficult to maintain that culture and maintain that camaraderie and communication, but it's critical. And It's critical for so many reasons. I mean, union organizing is just one of them, obviously, right? You want to avoid legal claims. You want to avoid too much turnover. You want to be able to recruit the best and the brightest. And you can't do any of that if you have a culture where employees are not feeling respected and they're not feeling like they're being treated fairly. So that is a really important focus in terms of how you can maintain a union-free workplace. And it's often not given enough consideration by employers. I think a lot of employers just don't realize that that is what's going on. Like, that's the issue. We want to be respected. We want to be told as soon as possible when there's a change in our schedule. We want to know what the expectations are for us to get an increase in our salary or our hourly rate. So it's all about creating this environment where people feel like they can succeed, that if they do their best work, they're going to be recognized for that. And that's just not what most employers think of as the main issue for union organizing. They think it's the money. It's not that the money doesn't matter. It absolutely does, but it is not the driving force. So that's important. The other thing I really want you to think about, and this again is a national issue, it's a federal issue. It does not relate only to California, or what your policies say. Because the National Labor Relations Act comes into play in ways you might not imagine. Your confidentiality policies, your non-solicitation policies, your technology use policies, your speaking to the press policy, right? Who has the ability to speak on behalf of the organization. A lot of those policies need to be looked at through the lens of the National Labor Relations Act. You need to be able to look at them, at those policies, and say, okay, am I doing anything to infringe on my employees' Section 7 rights? Okay, and Section 7 is the part of the National Labor Relations Act that addresses employees' rights to engage in collective bargaining, right? Communication for the mutual aid and protection of everyone. So when you're enacting policies that may restrict your employees' Section 7 rights or may infringe on those rights, you're going to have a problem under the National Labor Relations Act. And unfortunately, sometimes the way those problems are resolved is the board will just say, well, you're going to be a union workplace. It's a little more complicated than that, but the big picture is, the remedy is, we're going to let the union come in and represent your employees. That is the last thing you want if your employees haven't even voted. Okay? So it's very important to think that through and make sure you understand the ramifications of the policies you are putting in your handbook or your manual. Now, if you're a public sector human resources professional or employment lawyer, let's say you work for the state of California, there are a number of bargaining unit agreements that apply to employees who are represented in the state. And you need to know those backwards and forwards. You may be part of a negotiating team if you work at CalHR. There's always something going on in this area. The state is really the largest unionized employer in the state of California. So working for the state, there are a number of unions that are involved. Outside of the state of California, in the private sector, union membership is relatively low, but it's increasing. And part of that, I think, is the economy. People are worried about, the price of milk, the price of eggs, the price of everything. And sometimes they look at the union as being a panacea to that problem. But if you talk to them after an election, employees understand that, the union can't guarantee us a raise. The union can't say that we'll always get an increase. It just doesn't work that way. So when you actually lay out for employees how union representation works, when you're in that process of having a union, what's called demand recognition, right? Where they're asking to be recognized as a representative of your employees, you can actually get a long way by being transparent with your employees and just explaining how things really work. There are all sorts of tools and resources available to you. One thing I will say is if you don't want to be a union employer and you find out that there is some union organizing going on, maybe you're finding that there are some authorization cards, little cards that the union will give your employees, or people are meeting after work, you definitely want to contact a labor lawyer. We are employment lawyers. We deal with employment law. We do dabble in labor law on related issues, but if you're having a potential union election drive, you're going to need true labor lawyers or labor consultants who can help you through that process, because there are a million rules and regulations about what you can and can't do, and you don't want to unwittingly violate any of them and then have the remedy be that the National Labor Relations Board invites the union to your workplace. Okay, so lots to talk about here, everyone. Take a look at those policies. Think about where you are. Obviously, like I said, if you're a state employer, you're going to be unionized, and you just have to work to have a great relationship with the union so you can meet the needs of your employees and your customers, your vendors, etc. So thanks so much for joining me here today, everyone. Go out and have a great week, and I'll see you next time. Workplace Wake Up, including our guests and hosts, do not provide legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction. If you enjoyed this episode and would like to spread the word, please share it with others. Post about it on social media and/or rate and review it. You can also follow us on LinkedIn, Twitter, and Facebook, and email us at info@shawlawgroup.com.